Welcome back, everyone, and I hope you enjoyed the session this morning with Jo. I'm now delighted to introduce Jog Hundle. Now, Jog Hundle is an employment lawyer and partner for Mills and Reeve, and she heads up a team of 20 people and has been doing this for 25 years. So she covers a wide range of employment issues, everything from 2P to disputes with very senior people too. And menopause, of course. Jog's been our go-to person now for 4 years. And what we're going to cover in this session is menopause and employment law, what your responsibilities are. And as I was saying earlier, Jog, this is very, very timely, of course, because we have the government inquiry. So we're all hedging and wondering what's going to happen. Is that inquiry going to lead to the solution or the conclusion that menopause or that employment law needs to be changed? I might come back to that later, but I'll hand over to you to share your slides.
So welcome everybody. Thank you very much for inviting me. I'm going to consider the employment law aspects of menopause in the workplace. So according to ACAS, around 2 million women over the age of 50 have difficulties at work as a result of their menopause symptoms. And what's more is that 1 in 8 of the workforce are women aged over 50, and that number is rising. So women over the age of 50 are the fastest growing group in the workforce. And research is also demonstrating that during COVID, the position of women in the workplace has been much more impacted than men. We also know that many women hide their menopause symptoms at work and feel that there is a stigma around talking about the menopause. So it's so clear, abundantly clear, that we have an issue impacting upon both employers and employees, which needs considerable and urgent attention. So my presentation divides into 4 areas: understanding legal responsibilities, risk assessments and addressing findings, lessons learned from recent ET decisions, and examining menopause-focused guidance within the workplace. So if I move on to my next slide, I'm going to look at the employment law implications. So next slide. And then if we firstly examine where the employment law obligations underpinning menopause in the workplace sit, we're directed to the obligations set out in the contract of employment, which contains a duty of mutual trust and confidence. But the key legislation is the Equality Act, and that protects workers against discrimination. And then the health and safety legislation protects health and safety at work. So you'll hear more from me on the Equality Act later in my presentation. And the ACAS codes, which underpin the legislation, also highlight legal obligations as well as good employment practices. And these obligations are obviously supplemented by an employer's own specific internal policies and procedures, which are key to training and educating the workforce. As Deborah said, the Women and Equalities Committee inquiry, chaired by Caroline Noakes MP, is seeking written representations on its scrutiny of existing legislation and workplace practices, and whether they adequately protect employees impacted by the menopause, who the inquiry described as the invisible cohort. So clearly there's an impetus here, because there's certainly an acceptance that employers need to do more, and we need to revisit our legislation, particularly the Equality Act, to see if any changes need to be made. And if you wish to contribute to the consultation, that closes on the 17th of September. Moving on to my next slide, I want to examine the unfair dismissal jurisdiction. So the law of unfair dismissal imposes a duty on employers to act fairly when dismissing employees. So moving really to the outset, an employer must have a good reason for dismissal and must follow its own disciplinary or dismissal processes, or at least a statutory minimum. So you'll all be aware that the qualifying period of service to bring an unfair dismissal claim is 2 years from commencement of employment. Although there are some exceptions to the 2-year qualifying period of service, and that is, for example, if the worker is raising a whistleblowing disclosure. There's also a right to claim constructive dismissal when an employee is forced to leave their job against their will because of their employer's conduct. So, for example, a resignation in response to an employer not acting when an employee has been bullied or harassed. I'm moving on to the next slide now to look at discrimination. So the Equality Act sets out 9 protected characteristics which protect workers against discrimination. The most relevant areas for protection in cases involving the menopause are sex, disability, and age. So unlike unfair dismissal claims, discrimination compensation is uncapped. And in the most severe of cases, compensation covers the loss of earnings and pension loss also for the remainder of the employee's career. And also discrimination rights are called day one rights. There's no need for the 2-year qualifying period of service that's necessary in an unfair dismissal claim. And in discrimination cases, named employees can also be cited separately as separate respondents to the claim for which they have personal liability. So co-workers can be joined into the proceedings as separate respondents. So in terms of assessing prospects of success, every case will depend on its own individual facts, but employers are very much advised to follow best practice in order to reduce their risk profile. Also, I'm staggered to see that really the low number of cases which expressly refer to the menopause despite our changing workplace demographics. So that highlights to me that there's still very much a stigma in discussing the menopause in the workplace. So there are plenty of cases where menopausal symptoms are being described, but the possible connection with the menopause is not being expressly spelt out by those involved. So that raises an issue. Moving on to the next slide, I just want to examine discrimination concepts. So direct discrimination is where a worker is treated less favourably because of their protected characteristic. So, for example, disability, sex, or age. So they're 3 of 9 protected characteristics. And they're the protected characteristics which are raised more commonly in menopause-related cases. So an example of direct discrimination is where a woman loses out to a promotion opportunity to a less qualified male. Indirect discrimination is where a neutral policy is applied to everybody in the workplace, but which can't be shown to be a proportionate means of achieving a legitimate aim. So, for example, an employee who's finding it difficult to concentrate as a symptom of the menopause may not be able to meet certain performance targets as easily as her colleagues. And those performance targets would need to be justifiable to avoid a finding of indirect discrimination. So examining disability discrimination further on my next slide, a person has a disability if they have a physical or mental impairment and the impairment has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. So substantial is defined as more than minor or trivial, and long-term is 12 months or more. So many cases related to the menopause will be brought under this disability strand. An example of a disability is poor concentration, where it takes much longer than it usually would to complete a daily task. So at the moment, pregnancy and maternity is a protected characteristic, but menopause isn't. So the Equalities Inquiry is looking to see whether or not menopause ought to be the 10th protected characteristic. So moving on to, still on disability discrimination, my next slide. Discrimination arising from a disability is where a worker is treated unfavourably because of something linked to their disability. So by way of example, it's the very issue examined in the Davies case involving the Scottish Courts and Tribunal, which we'll look at shortly. So is there a link between an employee's alleged misconduct and disability? And then a duty to make reasonable adjustments. You'll be familiar with this duty. So it's where a policy, practice or physical feature puts the disabled worker at a substantial disadvantage when compared to the worker who's not disabled. And that duty is to take such steps as are reasonable to avoid the disadvantage where there is a prospect that that adjustment will assist. So for example, a reasonable adjustment may be reorganizing work. So my next two slides highlight examples of everyday and simple reasonable adjustments. And the obligation to make reasonable adjustments may be triggered, for example, in sickness and performance management scenarios. And the employer may be in a position where the sickness triggers or performance measures need to be adjusted in order to take account of the menopause. And you'll see from these reasonable adjustments, they're common sense, they're not costly, and they're easy to put into place. So if we look at the second slide, that sets out examples of further reasonable adjustments, adjusting working hours, particularly with the emphasis on working from home, having increased the support of occupational health, just simple things like access to fresh drinking water. So I now want to move on to my second strand of my presentation, which is to look at the role of risk assessments, which I cover in the next slide. So moving on to the next slide, there's a legal duty on employers to carry out a suitable and sufficient assessment of health and safety risks in the workplace. And that's under the Management of Health and Safety at Work regulations. And that risk assessment should cover specific needs of the employee experiencing the menopause. Now, the Health and Safety Executive have examples, really good examples of risk assessment templates that you can use, and you can tailor those for specific circumstances relating to the menopause. But what's clear is that the employer is under a legal obligation to ensure that the working environment will not worsen the menopausal symptoms. So that's a key element that both an employer and an employee will need to work through together, the risk assessment. And then it doesn't stop there. So moving on to the next slide, once the risk assessment's been carried out, there's a duty on the employer to address the findings in the risk assessment. So an employer is required to take action. It's a legal duty to eliminate any identified hazard. And if that's not possible, to control the risk. So our top tips are to provide, obviously, an accessible and well publicised menopause policy, and also to tie that in with a risk assessment policy, occupational health access, and also for employers and particularly managers to be mindful of the working environment and access to facilities. But throughout this morning, all our panel speakers will say that the most important element in everything we're covering is educating all parties in the workplace, not just managers, but all employees in the workplace. And of course, there's a duty to implement reasonable adjustments. So moving on to my next slide, what I want to do now is to examine some of the recent tribunal decisions, because we have had an increase and there are some interesting case studies and lessons to be learned. So moving on to the next slide, I'm going to examine the case firstly of Donachi and Talent Technology Services. The question here that was asked by the tribunal was to consider whether typical symptoms of menopause could amount to a disability. And the relevant answer is found in paragraph 22 of the tribunal's decision. So this is a first instance decision. It's not an employment appeal tribunal decision. So this decision is not binding on other tribunals, but it still has impact. So the judge said, I see no reason why in principle typical menopausal symptoms cannot have the relevant disabling effect on an individual. So the descriptions of the potential impact of symptoms on day-to-day activities seems to me particularly relevant to this claimant situation. So this is the key element. The judge said, I have little hesitation in concluding that the effect of her menopausal impairment on her day-to-day activities is more than minor or trivial. The range of her daily activities and her ability to undertake them when she would wish, with the rhythm and frequency she did, is markedly affected as set out above. So this is a really helpful decision. And I think going forward, it'll be a useful one to quote when making representations to employers who will obviously be aware of the extra obligations imposed upon them in the case of disability, but they may not know that such additional protection is required for the menopause and related experiences. So I think it'll only be a matter of time until this issue is aired at the EAT. But for now, this tribunal decision is a helpful one for women experiencing difficulties at work related to the menopause. So the second case I want to examine, still on this slide, is Daly and Optiva. So this employee's in her 50s. She suffered physical symptoms including hot flushes, night sweats, headaches, joint pain, and tingling extremities. And mentally, she endured anxiety, panic attacks, disrupted sleep, memory lapses, and difficulty concentrating. And she'd also been diagnosed with an overactive thyroid. But her symptoms were described as arising predominantly from the menopause. And she issued tribunal proceedings alleging, amongst other things, that her employer had failed to make reasonable adjustments to cater for her disability. So this was a preliminary hearing, not a full hearing, and the judge had to consider whether or not she was disabled within the meaning of the Equality Act. So the tribunal found that this employee's difficulties with concentration, memory, and fatigue substantially impacted on her ability to remember work processes and to read and understand documents, and that she had significant difficulty in continuing her active social life and was so tired during the day that she was unable to watch a film through to the end without falling asleep. So other day-to-day activities that she found challenging due to her condition included carrying heavy shopping and driving long distances. And her symptoms were long-term because by the time she came to tribunal, they'd already persisted for more than 2 years. So you won't be surprised to hear that the tribunal ruled that she was disabled, and that has opened the way for her to pursue her claim to a full hearing. So again, a useful decision there. I want to now move on to my next slide and look at this decision involving Gallagher and Abellio. So this employee was dismissed following a breakdown of her relationship with her manager, and she claimed unfair dismissal and disability discrimination. And she said it was due to symptoms arising from menopause and depression. So issues came to a head during a performance review meeting at which Miss Gallagher was dismissed, but she'd been given no warnings and no procedure had been followed or a right of appeal given. So these are basic elements that ACAS expects an employer to follow, and they will be set out in the majority of performance management processes and procedures. So despite these omissions, the dismissal was held to be fair and non-discriminatory. And this was because and I'm examining the discrimination element at this stage. This was because Miss Gallagher had underplayed her symptoms and she wasn't aware she was disabled at the time. So how can her employer have known that she was disabled? So that's why this case failed. Knowledge of her disability could not be imputed to the employer. So there is an imperative for an employee to make their symptoms known to their employer, or else the danger is they could fail in the tribunals. So that is an example of a case that went against an employee. So I want to move on now to my next slide and look at a case involving Miss Davies and the Scottish Courts and Tribunal Service. So Miss Davies was employed as a court officer and she had experienced substantial medical problems related to the perimenopause. And she'd received medical treatment for a number of years. So she had been prescribed medication for cystitis, and she took this medication by dissolving it in water. And she returned to the courtroom, which is her place of work, following an adjournment, and her water jug had been emptied. And then she spotted two men in the public court who were drinking water. So she asked them where they'd got their water from, and she explained that her water was medicated and now her jug was standing empty. And one of the men sort of launched into a rant. So he wasn't best pleased and he was fairly offensive. And the employer investigated the incident. It was investigated firstly as a health and safety incident by the health and safety team. And this led to a disciplinary investigation. And the allegations against Miss Davis were that she'd shown no remorse for her actions and she didn't appear worried that the men had taken this medication. So that was the health and safety risk. And the investigation concluded that she'd not shown the values of the organisation and recommended formal disciplinary action for gross misconduct. She was referred to occupational health, and they confirmed that she had perimenopausal symptoms. Before the disciplinary hearing took place, Miss Davis realised that the men couldn't have been drinking her water because it wasn't pink, but it was a symptom of her menopause that she'd become confused and hadn't realised, and it had taken her some time to realise the situation. So given these circumstances, and she'd drawn all this to the attention of her employer, and there was medical advice which drew a link between her symptoms and the alleged misconduct, it's not surprising the tribunal found that she'd been unfairly dismissed and discriminated against because of something arising from her disability. And an order was made for her to be reinstated, and she received her back pay and injury to feelings. So she received 15,000 back pay and 5,000 injury to feelings, and an order was made for her to be reinstated back to the Courts and Tribunal Service. So even following a reinstatement order, an employer doesn't have to follow that order. It can pay additional compensation should it not wish to follow the reinstatement order. So not only has there been bad publicity and an award made against the employer, their legal costs would have also been significant. So not a good day for the Scottish Courts and Tribunal Service. Now I want to examine another case. So moving on to my next slide. Miss Kovnatska was a recruitment worker with breast cancer. This is a really, really sad story where, I shouldn't say story, a case where this recruitment worker with breast cancer was fortunately successful in her claim for harassment against her employer, Textbook Teachers Limited. So she discovered a lump in her breast, and she was subsequently diagnosed with breast cancer, and she required surgery. And there were a series of conversations between her and her manager, and it was alleged that her manager said, it's not like you're going to die. What do you need that amount of time off for? It's only early stages of cancer. It's no big deal. And the employee had been advised that she would be forced into menopause at the age of 37 and no longer able to conceive children. And so, you know, we're looking at very, very severe circumstances for this employee. And the manager's also alleged to have said, you're lucky to have a free boob job from the NHS. And he asked if she would be happy with her new breast size, if she was going to have another free boob job, so the other match. So this is just simply horrendous. So the claimant, not unsurprisingly, brought claims of direct disability discrimination, a failure to make reasonable adjustments, and harassment related to disability. So surprisingly, the claims for direct disability discrimination and failure to make reasonable adjustments failed, but the tribunal did find in her favour in relation to the harassment claim. So those comments I've just related, they found that they showed a lack of insight, sensitivity and empathy, which had the effect of violating the claimant's dignity and creating an offensive environment. So with harassment, it has to be linked to a protected characteristic. And importantly, the manager, he didn't intend to be offensive, but we don't need to prove intention in a harassment claim. So a really, really sad case, appalling that actually it went all the way to tribunal and they didn't seek to make amends earlier. And much more appalling that the manager didn't know that this was not unacceptable behaviour in the workplace. So looking at my the second case on this slide, the case of Merchant and BT. So Miss Merchant was dismissed following a final warning for poor performance. She'd previously given her manager a letter from her GP, which explained that she was going through the menopause and it was affecting her level of concentration at times. So the medical evidence was there. And the manager, however, chose not to carry out any further investigation. And he made the mistake of using his wife's experience and the accompanying HR manager's experience of the menopause as relevant evidence in his decision-making. And he dismissed Miss Merchant for poor performance. And so the tribunal described his approach as bizarre and irrational, and said that a man suffering with comparable symptoms related to impacted concentration would not have been treated in the same way. And he'd also failed to secure occupational health medical evidence despite BT's policy requiring it. So, you know, a bad day for BT. Looking at the final case on this slide, the Bon Marsh decision. It's another case of the Scottish Employment Tribunal. So you'll see we've got a number of employment tribunal decisions now coming through. So that is a significant change. There is an increase in the number of cases, but what we lack is an employment appeal tribunal decision. And I don't think it'll be long before we have one because of the increase in the number of claims. So in the Bon Marsh decision, the claimant claimed that she'd also been subjected to harassment and abuse by her manager over a sustained period. And she again is a female going through the menopause. Her claim before the tribunal was of age and sex discrimination. The claimant worked in sales in a supervisory role. She reported to the store manager. She got on initially really well with him, but things changed when she was going through the menopause. He would humiliate her in front of other staff. They would laugh at his remarks. He also suggested that she should apply for a job elsewhere. He called her a dinosaur in front of customers. He said that she couldn't staple two pieces of paper together due to the menopause. He refused to adjust the temperature in the store. And they were going through a restructure and he encouraged others to apply for her job. She raised it with management and her concerns were ignored and his behavior got worse. I mean, this is really sad. She then goes on to suffer a breakdown and was prescribed antidepressants. But she returned to the workplace and the store manager was cold towards her. And despite HR having agreed she could work 4 hours a day as part of her phased return, he rostered her to work a full week the following week. And he said, well, if you want to work part-time next week, you need to take holiday. So this was the final straw and she resigned. And not surprisingly, the tribunal held she resigned because of her store manager's treatment. And that treatment had led to her becoming mentally unwell. And she was awarded £28,000, and 18,000 of that was injury to feelings. And the rest, the 10,000, was loss of earnings. So a big lesson learnt there. And that's what I'm doing in my next slide, examining the lessons learnt. So we know that more women than ever will experience menopause at work, simply because there are more of us at work. And there's also a significant rise in tribunal cases relating to the menopause. I mean, the key element is there's still only a very small number, but they will increase. And common menopausal symptoms may amount to a disability. So employers may discriminate against an employee if they fail to make reasonable adjustments and they fail to assess whether or not there's a causative link between the menopause and the employee's behaviour before taking action. So that was the Davies case. And offhand abrasive comments relating to the menopause may amount to harassment. And, you know, some pretty off the acceptable range of comments have been made in the two cases we've examined. Quite how people stood by and allowed those comments to be made, I really don't understand what sort of culture would have been present in the workplace. So it's important for managers to make menopausal symptoms, it's important for managers to take menopausal symptoms seriously and have open conversations with employees and seek medical advice if any issues arise before taking action. So I'm going to stop now to take a number of questions. I think Deborah's going to field the questions. I can see 12 in the chat function. So Deborah, do you want to pop on so that we can address these numerous questions?
Thank you very much, Jog, because it's a fascinating area, isn't it? And if you ask the question, is menopause covered by employment law? Absolutely, and it's likely to get even more intense, and we're seeing more tribunals happen. But this is very much about balance. So I know we'll, for the last minute or so, focus on policies, and I'll launch that slide for you. But I just wanted to ask you a couple of the questions that are coming up, because people are sort of saying, where you suspect that an employee may be suffering from menopause symptoms, but they have not disclosed this, but there is a performance issue. How do you approach this? And it's a fascinating subject because it can be very daunting for people.
Absolutely. So it is a difficult conversation. It's a conversation a manager needs to actually prepare for. And it is best to be open and transparent, empathetic and sympathetic. Perhaps not to launch with that, but to say, invite the employee to talk about how they're doing, what support measures are in place, what additional support measures could be put into place. Is there any medical evidence? You know, and then drawing discussion to raise, do you think it could be connected to anything else? Maybe the menopause, have you thought about that? Have you considered it? So obviously in a very, very understanding way, in an educated and trained manner. That would be my tip.
And you know, line managers are not born with menopause knowledge, and menopause is a mystery to many of us, not just line managers. So training is absolutely key to help them understand what menopause might look like and have it in the back of their head and think, could this be menopause? But they're not there to diagnose. So we wouldn't expect somebody to lead with, do you think this could be the menopause? We'll cover this more in Julie's session as well, in helping line managers open that conversation. But one of the other big questions that came in, Jog, was around when you were talking about discrimination, and you were talking about policies and practices, and you need to be mindful for those that could be experiencing menopause and have that as a disability under the Equality Act. If somebody's organisation has, for example, a policy and practice where they have to sit an exam to get promotion, yet with all of those symptoms, it's really hard to concentrate and pass that exam. Is that an example of where they might need to consider making an adjustment to that practice?
Yes, a perfect example. So additional time obviously is a commonplace adjustment. We know that from students sitting exams in main school schooling. And then having that discussion, it's having the engagement and the discussion, because these reasonable adjustments do need to make a difference. So different adjustments might need to take place for different employees, and the conditions in which the exam is being taken, that the environment and the facilities are also important. So that needs to be addressed head on, rather than waiting for it all to go completely wrong.
Absolutely, which brings me on to the final one before we do cover off on policies, just the high level on policies. But everybody recognises hot flushes. It's a stereotypical symptom, but the psychological effects, which Joe mentioned earlier, can affect behaviour in an individual. So if menopause can affect behaviour, what adjustments would you suggest would be reasonable in the workplace? It can be hard to manage this and address this. So, you know, it's all about balance and being supportive and implementing the right things. But, is there any guidance that you would give us around that?
Absolutely. Again, it's a question of engagement. So flexibility in terms of working hours can make a big difference. If there's a later start, the employee may be in a position where they can tackle the working day in a much better sort of frame of mind. So, you know, if somebody's unwell, they're not going to engage positively with their employees. There is going to be a poor atmosphere, and they are going to be the employee that nobody gets on with. So it's difficult for the team, but unless we have that open engagement and are open to looking at different ways of the team engaging, without obviously isolating the individual or marking them as being somebody different, then there's a conversation to be had. And if after taking those steps it's still not working, then there is an issue that needs to be addressed with that individual and their behaviours, because it's impacting upon the wider team. But we've done all we reasonably can. So this shouldn't, I mean, I've seen cases where it goes on for years and years and years, and the employee gets moved from one department to another. That is not tackling the issues or supporting the employee at all. And that's when we end up in tribunal claims.
Thank you very much, Jog, and absolutely agree with you there. So do keep your questions coming. But before we finish this session, because we've only got 2 more minutes, menopause policies are not law yet.
No.
They may be likely to be. Now, we'll give you all of these slides and this recording so you can recap on it, but I think it'd be worthwhile, Jog, and also, of course, you'll have Jog's contact details in there too. But could you just talk about menopause policies for a couple of minutes?
Absolutely. So the requirement to have employment policies is not something required by a piece of legislation. It is something that's built up through case law, and ACAS recommends that employers have a series of policies. So ACAS very strongly recommends a separate menopause policy, and that can definitely help both managers and employees have more meaningful discussions about menopause. So there's definitely a place for a menopause policy, but you need to look at your organisation. You might want guidance notes, you might want a protocol. So whatever works for your organisation to actually educate the entire workforce. And definitely having guidance, having a policy, having Q&As reduces the risk of grievances and tribunal claims, and it supports a better working atmosphere. And a menopause policy clearly should include details of what the menopause is, common symptoms, how best to facilitate open conversations. It's something we've referred to earlier today, the support available and the types of adjustments which could be considered. So, you know, throughout all this, and all the panel speakers will highlight this, as will Deborah, the importance of engaging with employees and having the confidence to understand symptoms, to put adjustments in place, are all important. So an employer who creates a strong work culture is creating a better workplace for everybody, not just employees with menopause symptoms. And as I say, as the awareness of menopause in the workplace is increasing, although we want it to increase rather faster than it is, legal claims will also increase. So employers are under an imperative to manage menopause with appropriate care and sensitivity. So yes, I don't know if there's any more questions for me, Deborah, or whether I've timed out.
You have. We're just about to go into a coffee break. We could talk about this for much longer, couldn't we, Jog? And one comment that we have is there is a mediation service available to resolve issues before you go to court.
Yes.
Which is very, very true. But thank you very much for sharing those. As you say, I know you said stories, case studies, they really do sort of hit you hard, don't you, around how hard it is, not just for the employee to be facing with that. So we've all got a duty really to create that environment where menopause can be easily talked about, that the right support's in place. And in the next session after the coffee break, we'll be talking to Julie Dennis, who will give you lots of top tips on how to handle that. So thank you very much, Jog.